So welcome back, distinguished delegates, for this afternoon session here in New York of our colloquium. I'm giving the floor to my colleague Jay, who's moderating this part of the discussion to walk us through the remaining draft provisions or draft clauses that have been prepared by the experts. Over to you, Jay.
Thank you, Anna. This afternoon, we'll be looking at draft provision 7 on confidentiality and draft provision 8 on evidence. Afterwards, we would like to also have a short discussion, a brainstorming discussion on how to develop the project further and what is to be presented to the working group so that we can also present that to the roundtable discussion tomorrow. First, because some of the speakers have difficulties joining and they have not been able to join due to personal reasons, I would like to give the first floor to Patricia so that we discuss draft provision 8 on evidence first, which actually is based on Article 27 of the UNCITRAL Arbitration Rules. And there is also an important or an interesting element about the use of AI in the collection of evidence and presenting them. So, Patricia, I would like to give the floor to you first. Thank you.
Thank you very much, Jay. And thank you to all of the organizers, the UNCITRAL working group, and to my fellow experts and all of the participants that are joining us, whether it be the morning, the afternoon, or the evening. I have worked together with Claire Morel at Westgrave to make this proposal to Article 8, which corresponds to the UNCITRAL Evidentiary Rule, Article 27. Unfortunately, she could not be with us this, so I will briefly present the work that we have created together. Now, I trust that everyone has access to the UNCITRAL note that we are discussing today and can look at the draft provision number 8. Before digging a little bit into that provision, I would like to state that Claire and I, when approaching this, felt that it was important to, one, ensure that we stay in the typical drafting approach and style of the UNCITRAL rules and not introduce an approach that would be very different than the style of the existing rules. Although the draft provisions are intended to be standard provisions, which could be an addendum or standalone opt-in rather than into the evidence rule. Now, if we look at the approach, the other important aspect is that particularly when it deals with technology and evidence, we're quite aware how quickly the landscape and the technology can change. Wanted to ensure that the rule was extensive and flexible to be able to adapt to the change that might be coming down the road. And also, on the third point, we are well aware that the particular types of tech disputes can vary widely. It can vary in terms of whether it's a small startup or if it's a very established, large, complex company. It can vary very widely with the type of technology in terms of the nature of the technology and the way in which it presents itself in the particular dispute. So we want to try to create a rule that would be adaptable to the particular circumstances of the case and the needs of the parties in the case. So having said that, in a few short minutes, I'll just through which all of you can explore in more detail. Hopefully we will discuss that the draft provision, paragraphs, 3 sections. And the first, and I think that you'll recognize from most arbitral rules, provides that at any time during the arbitral proceedings, the arbitral tribunal may require the parties to produce documents, exhibits, and then we add data, technical information, or other evidence within such period of time as the tribunal shall determine. So this reflects the existing type of flexibility which one finds in the UNCITRAL rule number 27. In some arbitral rules, the tribunal discretion to order a party to produce evidence is limited to a party requesting it, but that is not the case in the UNCITRAL rules nor in this provision. Importantly, the addition of data and technical information is intended to be broadly interpreted and not restrictive. And it also follows with evidence. And the idea is that this would allow for broader development and would not constrain the tribunal in being able to adapt the use of this provision to the needs of the parties, the case, and the particular type of technology which are presenting in the case. If we go then to the second paragraph, and then that paragraph we find once again at any time during the arbitral proceedings, allowing a great flexibility and operation of discretion by the tribunal. It may order that evidence be taken. And here we come into the particular technology adaptation, that an experiment could be performed in the presence of the arbitral tribunal, or an experiment which has been done and is reflected in the evidence could be repeated in the presence of the tribunal by the parties or by an expert that may be appointed by the arbitral tribunal. So this does not necessarily limit the parties from having an expert to present this experiment or demonstration. It does specifically allow that the tribunal may prefer to appoint its own expert any such experiment or demonstration, and once again be broadly interpreted. If we go then to paragraph 3, we find that each party shall disclose, and again we have a requirement of shall, to all parties and to the arbitral tribunal any use that has been made of technology, including artificial intelligence, for the purpose of collecting or complying with an order of the tribunal. And this again should be interpreted so that if technology or AI, any type of AI, has assisted in gathering, presenting, collating, and preparing the evidence, then the parties enter the arbitral tribunal. Upon such disclosure, a party may request that the use of this technology should be limited, and the tribunal may refuse or allow such a request, taking into consideration the circumstances of the particular case. So we see running through this proposed rule a great deal of flexibility and discretion given to the arbitral tribunal to adapt, and any adaptation and any exercise of the discretion allowed by the proposed rule should always be exercised, of course, with regard to the overriding and always existing considerations that the tribunal should exercise. And that is due process rights of the parties, efficiency. The idea is that we're trying to find an efficient solution that is well suited to the particular dispute, and the effectiveness, so that whatever the adaptations are to the particular case, they are very much driven by trying to ensure the effectiveness of the proceedings while protecting due rights and ensuring efficiency. And the idea is this post rule should allow both for the flexibility to adapt to the particular circumstances, giving discretion to the tribunal to ensure the due process, efficiency, and effectiveness, and to meet the needs of the particular case in light of the nature of the dispute and the technology which is involved in the presentation of evidence. Before I pass the floor on, I would like to say that it, of course, is probably obvious to everyone that such a rule, of course, will need to be dealt with in perspectives of the time periods that the tribunal moves, which is the subject of a different rule, with the case management conferences, and importantly with confidentiality, preservations of privileges, and other such matters, taking into consideration the particular burdens be imposed upon the parties in collecting and in presenting evidence and responding to the requirements of the evidence rulings that the tribunal makes. So again, while this is a standalone provision, it needs to be considered in light of the overall proposals for the draft rules, which we are doing today. So with that, I will conclude. I'm open, of course, to any questions, and I pass the microphone on.
Thank you, Patricia. Of course, we'll get into the detailed provisions on evidence, but I think one point that's kind of hidden, or actually you mentioned it in paragraph 3, is what we had discussed in Monday and Tuesday about the use of AI in different parts and different stages of the arbitral proceedings. For example, whether the tribunal would have the discretion to utilize it has somehow been discussed by the working group, or whether the tribunal would have the right and discretions to regulate the use of technology by parties is another question that may need to be addressed as we also take stock of the different developments in DRDE. So I think that is one issue that is kind of hidden there, but we will take note of that in the DRDE discussions, and I would like to open the floor for any comments on draft provision 8, which deals with the production of evidence and how they should be presented, the means of presenting such, whether experiments could be used as demonstrating such evidence. So I would like to open the floor on those topics. Switzerland, you have the floor.
First of all, I think what we should commend this expert group is that they made an attempt to link the proposed provision to the existing UNCITRAL arbitration rules. And I think that's an exercise that, in general, we or the experts producing these rules should do, and I think it is very useful. So the first two paragraphs are related to what we have in the rules, but expand the terminology of the evidence that is described there. So the question is, are the additional words of such nature that under the ordinary rules we can't order it or we can't require the production? And I think this is, we had that already when we were discussing the expedited rules. We have to be careful with proposing additions which may give the impression that the existing rules do not allow or provide for that possibility. To give, for instance, to take as an example the most advanced element, that is experiments. We had an arbitration with an offshore construction where the question of fit for purpose was an issue, and the tribunal ordered that a model be created and be used in experiments, to which the tribunal experts attended. So under the existing, well, that was not UNCITRAL, it was ICC, but under existing rules, that is something the tribunal has it. The question is, we have to be careful that we don't shoot ourselves in the foot by creating the impression that the existing rules do not provide that. The third paragraph, from my perspective, is particularly problematic. Because it is not the flexibility of giving power to the tribunal. It makes a requirement for the parties produce information and information about how they gathered the evidence that they present. And the way how it looks is it's an obligation, and it is related to discovery. And probably what is aimed at there are the e-discovery methodologies. But do we know that this discovery is required? And remember, we had the discussion about avoiding excessive discovery, but this opened the door for even further discovery procedures. So I think that clause is particularly problematic. But if what you, Mr. Chairman, have flagged was a different aspect, that the tribunal can request, if it has a vast file of information, request to be assisted or obtained by itself the technology to peruse and to analyze the vast amount of evidence produced to it. So that's a different point, but I think that may be something that should be considered in this context. But in general, the way how paragraph 3 now is formulated, I think gives rise to most serious concern. Thank you.
Thank you. I'd like to give the floor to Israel, who's on the platform, and then to Australia afterwards.
Hi, thank you. I'm sorry. We did have a reservation about the third paragraph, specifically with respect to AI. Since we're at the very preliminary stage in the potential use of AI for creating, collecting evidence, etc., it may be premature to address a mechanism for its use. And this is the case both with respect to the two situations regarding the use of AI in the explanatory notes, so the preparation analysis and the use of AI to collate documents. So we would suggest here to refrain from taking a prescriptive approach and giving time for the technologies to evolve so that we can better understand how they're used and what impacts they have. Also, a general point, I was absent from from part of the discussion, so I apologize if what I'm about to say has been said before. But one recurring point for us, at least, and it's been discussed in the past in many of our internal discussions, is asking the question, what is the need for specific rules since the tribunal already has certain powers? So I'm trying to address here one of the points raised by the distinguished delegate from Switzerland. So it's granted that many arbitration rules, they provide broad discretions for the arbitration tribunal. And so arguably a lot of these things that the experts here have tried to do, which is address timelines, expertise, confidentiality, and evidence, the arbitration tribunal already can do these things. And so the question is, what are we adding to the existing powers? And as the distinguished delegate from Switzerland said, it might be perceived as, stating it might be perceived as detracting from what already exists. But our response to this question is that what we notice is that there's a problem, and that is that in many technology disputes, arbitrators are not equipped with knowing how to handle these things. And so by providing default rules, it provides them at least with some kind of a guidepost, a default that they can rely upon, and provide some certainty. And so this can assist the arbitrator or the arbitration tribunal in crafting, maybe in changing or in using his or her discretion in a different way, but at least it provides a basis upon which the arbitration tribunal can decide how to handle the case. And it's a basis that is particularly suitable for technology disputes. Thank you.
Thank you. Australia, you have the floor.
Thank you, Chair. We simply wanted to raise that we have some concerns. I appreciate that we're not in the process of drafting at the moment, but we feel that perhaps the current wording of draft Article 8 maybe seen to be a little bit prescriptive, and we wonder whether that might be rectified by incorporating language such as including but not limited to within the body of the various of the three paragraphs, so as to flag that these aren't the only things that are capable of being used to gather evidence. Thank you, Chair.
Thank you. Mr. Michael Fong.
Thank you, Chair. Distinguished representative, I heard the word e-discovery from distinguished speaker from Switzerland. E-discovery software can discover and classify the data stored or electronically stored information, ESI. Therefore, easily collect the required documents and submit them for review and production whenever a legal case arises. Right now, the power of technology to resolve disputes is exceeded by the power of technology to generate disputes. Justice delayed is justice denied. I think I recommend use AI, but need regulation. ODR is not just use AI to replace the human. He is neutral. Use neutral as third party to use AI as fourth party to prevent or resolve disputes. Thank you for your attention.
Thank you. Are there any other comments on draft provision 8? I note that it takes a slightly different approach from the other provisions in the sense that it actually develops from the UNCITRAL arbitration rules and clarifies the meaning of the UNCITRAL arbitration rules. And the working group, has actually done that when we prepared the expert arbitration rules on whether we're trying to give robust discretion to the tribunal and to at the same time to make sure that it is still possible under the UNCITRAL general arbitration rules to do so. So I think we and the experts would need to take this in mind. I also noted the comments by some of the delegations that paragraph 3 may be a bit too prescriptive, and also that we may need to be careful about the use of AI generally in putting them into a rule. Yes. And before we move on to the next article, draft provision 7, I would like to give the floor back to the expert who presented the text. Patricia, you have the floor.
Thank you very much. I appreciate the comments that have been made by the distinguished delegates and experts. And I would like to note that, as stated in the explanatory note that accompanied this provision, when it comes to paragraph 3, one needs to also take into consideration where any use of AI and of definition of what might be considered, but a distinction between whether it was by enhancing the use of the human that was actually doing the job. This was purely an artificial intelligence doing the job. And again, I appreciate comments that were made, and one should bear in mind that the tribunal does have the power to reject the request by a party as regards Article 3, so that perhaps the prescriptive nature that we're discussing may need to review may be more to whether or not it needs to be disclosed and what would be the form of the disclosure. And going back to what was said before, we need to consider that if tech rules adaptations are being used, that case management conferences, these issues need to be addressed early on as to what things may come up and how they may be managed. And CMCs should be, perhaps in particularly complex cases, not a one-time thing at the beginning of the case, but should be revisited as the case develops. And the idea is to try to seek a balance so that the tribunal and the parties can work together to find an appropriate solution. But we do take all the notes back to the drawing table, and we'll take them into consideration. So thank you very much.
Thank you, Patricia. When we were discussing AI in the context of the digital economy, we are also looking at how much the human involvement and the autonomous nature of the AI actually could kind of differentiate the different situations. And I think that is also something that we need to take on board as we continue work on this project. With that, unless there are any other comments that needs to be made on Article Draft Provision 8, I would like to move on to Draft Provision 7, which on confidentiality, which Elliot also touched upon briefly during his presentation yesterday. But to present Draft Provisions 6 and 7, we have Switzerland.
I apologize for going back to Article 8, Paragraph 3. I think in this context, there is a larger problem. Article 3, the Paragraph 3 now is drafted merely as an element of document production or discovery. The point is the point is a larger one. In new technologies, there may be information available only to one party. In a license contract or developments. So the question that needs to be addressed here is access of one party to information of the other. So that goes beyond the normal document production. And I think the experts should go, I apologize, the experts should look further into the question how this can be regulated, because there is obviously a conflict with the confidentiality provisions. But it is a justified concern of a party to a dispute that involves especially new technologies, that it has the right, or that it should be possible of receiving in some form information on the other technology, and then we have to balance between the common law discovery approaches and the civil law rules on the party producing only what is necessary for its case. But we may have to go there beyond our reservation in the civil law countries against document production. So the recommendation this delegation is making to the experts to look further into the needs of substantive information, about, not just about the way how information was gathered as Paragraph 3 now is drafted, but also information on the substance of the technology that is an issue. Thank you.
Thank you. I think that's a good bridgeway to our next provision, which actually deals with confidentiality. And I mean, we take note of the comments by the Swiss delegate that in the information technology-related disputes, it might be that there may be an imbalance between the parties' access to the information, and that needs to be taken into account overall, not only in this provision, but as a general idea that we need to consider. With that, I would like to pass the floor over to Monica, who is here to present draft provisions 6 and 7 on confidentiality, which deals with both outbound and inbound confidentiality. Monica?
Thank you, Jay. Ladies and gentlemen, distinguished representatives, it is a great honor to speak at this colloquium and to present the provisions on the confidentiality. Yesterday and also today, we were discussing the definition of the technology disputes, in which, as other speakers said, the focus is the nature of the underlying transaction, which is the technology. And also it was discussed that the resolution of such disputes requires significant technical expertise. This goes hand in hand with the fact that technology-related disputes often contain technical and scientific information, trade secrets, and data that are sensitive to confidentiality and from which technology-based companies derive significant economic value. At the same time, many of such innovations are not patentable, and we can see increased desire to use trade secrets as a way of protecting inventions and technology as opposed to patents. In this kind of disputes, privacy and confidentiality is really one of the key attributes, and it is considered that arbitration provides this significant advantage. The expectations of users of arbitration that even the existence of their disputes will be kept out of the public domain are nonetheless not warranted in many arbitration rules, including the UNCITRAL arbitration rules. The UNCITRAL arbitration rules actually contain very narrow confidentiality provisions and address only specific aspects of the process, specifically the privacy of the hearings and the confidentiality of an award, unless the parties agree otherwise. Likewise, the model law is absent from any provisions on confidentiality. The UNCITRAL notes on organizing arbitral proceedings of 2016 expressly said that they leave a desired confidentiality regime up to the agreement of the parties, should the confidentiality be a concern or priority in the relevant case. Such agreement would definitely provide certainty, but the notes do not address the question of the parties' duty of confidentiality when their agreement is silent. So the question here is really whether the technology disputes represent such cases where the confidentiality is critical for the dispute resolution and the requirement of protection of technical and business information is omnipresent, basically in all cases. Here on the slide, you can see extracts from two surveys conducted by Queen Mary and White & Case in 2018 and 2021, and they illustrate that 87 respondents still consider confidentiality in international commercial arbitration to be of importance, and most of the respondents believe that confidentiality should be an opt-out rather than opt-in feature in arbitration. In the 2021 survey, it is interesting that many participants believe that cybersecurity measures will increase in importance. The surveys did not address specifically technology disputes, but show the overall dispute resolution perception. It is fair to say that actually there is still a little consensus on the overall debate about confidentiality, and that it can be very difficult to elaborate a general confidentiality rules. However, it doesn't need to be so difficult to address it with respect to these specific high-tech disputes, because the guidance for the tribunals or developing the confidentiality standards will be of value for the predictability of the parties, the certainty, and also for the confidence of the users or disputing parties in technology disputes. It is also fair to say that while confidentiality is still the default rule in international commercial arbitration, the transparency has become the trend in investor-state dispute settlement. And maybe this is the area which will require a specific attention, because states can also be parties to technology disputes. Next slide, please. As you are aware, the duty to confidentiality has two facets, which with basically potentially different scope of protected information. I call it the outbound confidentiality, in the sense of non-disclosure to third parties not involved in the arbitration of information relating to the arbitration. And this aspect is basically covered in other arbitration rules, like LCIA or Swiss arbitration rules. The duty of confidentiality is also implied in a number of legal systems. And also parties usually or very often include a confidentiality clause in their underlying contract. The second facet is the inbound confidentiality, which actually relates to protection of information before it is produced or disclosed within the arbitration. And this relates to the trade secrets, know-how, etc. And this confidentiality concerns circumstances in which certain information is deemed to be confidential to one of the parties in the arbitration. And this aspect is rarely regulated in arbitral rules, with a really few exceptions. Say, for example, the WIPO arbitration rules, Liechtenstein rules of 2015. There is a general procedural provision in the revised ICC arbitration rules, and also there are some provisions in the Permanent Court of Arbitration optional rules for arbitration of disputes relating to the outer space activities of 2011. So let me briefly discuss both facets of the confidentiality and the draft proposal. Next slide, please. First, this is the draft provision number 6, and this deals with the outbound confidentiality. The suggested scope of the confidentiality obligation in the draft is quite broad. It prohibits disclosure of all information revealing the existence of the arbitration and all materials in the arbitration proceedings, which are not otherwise in the public domain. It also covers information and documents created for the purposes of arbitration, as well as any documents provided by any party in the proceedings, including pre-arbitration documents which were not in public domain. At the same time, paragraph 1 also provides circumstances in which disclosure of confidential information is permissible. Basically, there are 4 groups of grounds, which I think are also addressed in other rules. The first ground relates to the enforcement or challenge of arbitral award or to pursue a legal right. The second and third relates to the compliance with provisions of law or requirements of disclosure required by governmental bodies. And the third reacts to the disclosure or to non-parties to arbitration, like professional advisors. Paragraph 2 then extends the undertaking also to the arbitral tribunal and any person appointed by the tribunal. Also, it contains an obligation of each party to obtain the same undertaking of confidentiality from all those that the party involved in the arbitration. Paragraph, I will not mention all the sections, which I think as regards the outbound confidentiality are not that controversial. Paragraph 5 imposes a duty to inform upon the disclosure, but this was mentioned actually by Elliot yesterday, that this provision can maybe generate disputes between the parties, and that this could be reconsidered, the redrafting of this provision could be still reconsidered. Paragraph 5 actually says that it entitles party to seek protection from the arbitral tribunal. Now I will move to the draft provision 7, the second facet of the confidentiality. Next slide, please. So this deals with the inbound confidentiality. This is confidentiality over information of intrinsic value shared between the parties in the proceedings, or actually where sharing of business data directly with a competitor would raise competition or antitrust concerns. Significant provisions on the treatment of confidentiality of this type are frequently absent in most arbitration rules and laws. At the procedural level, this issue comes within the scope of the broad powers of arbitrators to govern the proceedings. The tribunal's general procedural powers, however, do not seem to be sufficient to authorize the tribunal to determine confidentiality obligations at the substantive level, unless the parties, unless authorized by the parties. The WIPO arbitration rules that were crafted for technology subject matter disputes have contained very detailed provisions on protection of trade secrets and other information of commercial or industrial significance already from 1994. And I have to say that without not many revisions actually of the provisions. And these rules can serve as a useful starting point. Very similar provisions were also included in the PCA optional rules for arbitration on disputes of outer space activities that are otherwise based on the UNCITRAL arbitration rules. The existence and scope of confidential information would normally require determining the law applicable to the issue, which in turn is likely to require a choice of law analysis. And this exercise could prove very difficult, especially if there are several competing applicable laws. Therefore, a precise definition of what would constitute confidential information would be helpful, and this is provided in the paragraph number 1. And here in the draft proposal, it is limited to confidentiality on the ground of commercial, scientific, or technical sensitivity. This substantive confidentiality provision would be binding on the parties by virtue of the arbitration agreement and if it is contained in the rules. Based on paragraph number 3, the tribunal will determine whether relevant information is to be classified as confidential and whether the absence of special measures of protection in the proceedings would be likely to cause serious harm to the other party invoking confidentiality. The requirement of serious harm must be considered on a case-by-case basis and will include a balancing by the tribunal of competing interests. Paragraph 2 provides that the plea of confidentiality can be invoked basically by both a party resisting the introduction of the information into the arbitration and also by a party seeking to rely on the allegedly confidential information. So basically this draft provision deals with protection of a party that is requested to produce information, but also as well with the protection of a party that needs to rely on information in its possession. Paragraph 4 and 5 then deal with the procedure of determining whether the information that a party wishes not to disclose or for which it requires special treatment is confidential. If information is confidential, then the tribunal will determine under what conditions and to whom information may be disclosed. Then the second sentence of the third paragraph envisages the possibility of limiting the disclosure of the respective information to specific individuals. This is something which was mentioned yesterday by Elliot, meaning the attorneys or clean teams. Paragraph 4 also allows appointment of a third-party advisor, which
Monica?
this is now, yes.
You can continue, but if you can speak a little bit slowly for our interpretation purposes, that would be great. Thank you.
Yes. Paragraph 4 allows the appointment of a third-party advisor, which is now a widely recognized approach in the context of document production. Such person can be better equipped with relevant expertise to determine whether the confidentiality concern is genuine. Such person can supervise the redaction process, monitor the disclosure or inspection of the documents. Paragraph 5 then envisages the appointment of a third-party neutral. This is in an exceptional situation where such a person would actually collect evidence and information which may only be drawn from the confidential information and to prepare a report answering specific questions put by the parties and the tribunal. Maybe this, the paragraph 4 and 5 will still need discussion over certain aspects of how the confidentiality advisor shall operate, because some information or specific issue arising from confidential information would be communicating only to him, but not disclosed to the tribunal or to the parties. I will conclude or saying that actually today the only sensible solution is to address confidentiality needs in each case and an early stage of the proceedings by means of a meeting between the parties and the tribunal, and either by concluding a confidentiality agreement or by procedural order on confidentiality handed down by the tribunal. And this obviously can require a certain time if the parties actually can agree on the mechanisms. What could help are examples of the suitable confidentiality protection arrangements, such as the creation of the confidentiality clubs or rules for the redaction of documents or limited presence of certain individuals at the hearings, etc. And all these measures, however, I think are most suitable to be addressed in a guidance or a confidentiality protocol than in the form of the rules. So thank you very much for your attention, and I pass back to you, Mr. Secretary.
Thank you, Monica, for presentations of the very detailed provisions on confidentiality, both outbound and inbound. I just wanted to draw the attention of the working group that indeed in the UNCITRAL arbitration rules, the only provision relating to confidentiality is the fact that the hearings are supposed to be held in camera, and then unless otherwise that the award may be made public with the consent of all parties, or where to the extent disclosure is required to protect or pursue a legal right or in relation to the legal proceedings before a court or other competent authority. So what we're discussing in draft provisions 6 and 7 is a slight departure from the UNCITRAL arbitration rules, where the level of confidentiality is not regulated in detail as we have in draft provisions 6 and 7, but it may actually provide some guidance to the parties that wish to have confidentiality regime applying to the proceedings as a whole. So in that context, also, as we had made, there was reference to the WIPO rules. We would also need to see if the WIPO rules would be applicable and whether and to the extent which we can refer to them when we discuss inbound confidentiality. And lastly, I also have to note that the working group itself has prepared the transparency rules, but that applies to investor state arbitration. But in the light that we have the transparency rules, we would have to look at both sides of the coin because, as Monica mentions, states are also parties to tech-related disputes. So with that, I'd like to open the floor for comments on draft provision 6 and 7. But in the interim, I would like to first gather inputs on draft provision 6, which deals with outbound confidentiality, where the information shared in the proceedings should not be shared with third parties outside the proceedings. Thank you. And the other expert who was active in this discussion has joined, so I'll give the floor to Krenguta first so that she can supplement what Monica has been able to guide us through.
Thank you. My input at this time is just to highlight one particular type of cases for which the inbound confidentiality is of particular relevance. And can you hear me? I'm sorry. Yes? Okay. And that is the situation of those cases where we have one, at least of the parties, a state or a state entity. At this level of evolvement of the technology, there is a large number of cases where states are involved in the way of either being the shareholders of the companies that are developing new technologies or having a saying into the nature of the information about that specific technology, which may be defined under the local legislation as being classified information. It may be classified by its nature, or it may be classified by the use. So it may be the technology itself or certain use cases of that technology. If that is the case, then arbitration in itself is at risk to not be as useful as it was intended to be to ensure the neutrality from nationality perspective. As a forum where it wouldn't be an imbalance in terms of the nationality of those deciding over the case in the use of local courts. So I'm saying that it might be a risk if the arbitrators could not access that kind of information, and that those would be prevented to participate as arbitrators in those cases. That is the case of the situations where the arbitrator would not get the clearance for accessing such classified information because of their nationalities, because the procedures for getting the clearance would require for the arbitrators to be nationals of that specific country. Now, in those cases, in particular, the last provision that was presented by Monica is of use, namely the confidentiality advisor. And that is the gate through which we may obtain both advantages of the on one hand, of the arbitration being conducted by arbitrator, which would be neutral from both parties in the dispute, and the other advantage of having the confidentiality preserved through this mechanism that would be that of the confidentiality advisor. That is the insight I wanted to share with you, and thank you for your attention.
Thank you. And indeed, if we look at the other provisions, we also had mentioned the involvement of neutrals and whether it's the neutrals or other expert that, I mean, it really depends on how you structure the whole rules and the model clauses, whether the neutrals would have certain functions in preserving confidentiality in that case. So with that, I would like to open the floor for comments on draft provisions 6 and 7, unless there are Switzerland.
The concern of the secretariat and delegates in the room, my voice has a little bit improved. I have a particular thanks, and it shows the close cooperation and the concern we have for each other. Thank you very much. Now, the first point I wanted to make is you have referred to the confidentiality the transparency rules. And in the transparency rules, we have the exceptions. And one thing this delegation suggests is to see whether the exceptions may be or should be correlated with the exceptions we have in the rule here, so that I haven't checked that at the moment, but it was very useful that you flagged this point so that we have a synchronization there. The points I have on Article 6 is the first one. Very interestingly, paragraph 4 refers to sanctions. Now, the damage or the result of a breach of confidentiality rules is a very complicated issue, and I remember there's one case where the award was annulled because the confidentiality rules have not been respected. But that is a sanction which is really counterproductive and not very helpful. The fact that in this provision the tribunal can impose sanctions, I think, is a particularly problematic issue. We've looked into this in the context of what the French call astreinte, where procedural conduct can be punished by the tribunal by a penalty. And that is very contested. There are only few legal systems that allow arbitrators to impose such sanctions. And I think that would require further examination, and I think it's a particularly interesting aspect, especially in the context of confidentiality, where it would be very difficult for the injured party to prove a specific damage, and where penalties are a common feature in confidentiality agreements. So we suggest that this point be further examined, to what extent arbitrators have the power to impose sanctions and how this can best be regulated. The other point concerns paragraph 7b, data protection. I would think this is a point, an issue that has become prominent in general in arbitration, and very little understood. When I appointed to a tribunal, I first inquire with the parties whether they have arrangements in place for data protection. Normally they don't, even if they are related to the EU. So I think it may be necessary, either in these rules or in general, to consider whether UNCITRAL can give either guidance or provide rules on data protection. That is all I have for the... I guess not. There's another point, which I'm not sure how it implies. If you have knowledgeable arbitrators who are familiar with the technology in the dispute, they may not be accusable or may not be exposed to reproaches for lack of impartiality because they are not involved with either party. But they may be in the industry, and the only reason why they are knowledgeable in the subject is that they have information from a competitor. We had that in a case where that was considered as a cause for challenge. Finally, the arbitrator was not removed, but it is something that may be quite problematic. I haven't thought it through, but I think it is something that needs to be considered. The more a person is knowledgeable as arbitrator or even as secretary of the tribunal, the more there is a risk of leaking information to persons that are associated with other parts of the industry. And especially in advanced technology, where the number of people who are familiar with the technologies risks to be very small, and that is a point that would need to be examined. I have no solution to simply flag this as a point for consideration. Thank you.
Thank you. I would like to give the floor to France.
Les intervenants.
I'd like to thank briefers for the presentation. I think these provisions, without being specific necessarily to technological related disputes, are provisions, or at least draft provisions, which are very welcome. I think the draft is a welcome. It's an attempt to address real problems we face in practice, in particular draft provision 7, 4, and 5. In a number of situations, and we see that you've given a lot of thought to this, in a number of situations.
Alors, sur les sanctions,
could be very helpful. This is particularly true when it comes to revealing information. There's the issue of the penalty, the astreinte, as referred to by our Swiss colleague, but that comes further on upstream. The issue of sanctions once information has been disclosed, that's a rather problematic issue, and it depends on the type of information that's been disclosed that may cause a prejudice, a commercial prejudice. It may have an impact on the money. It could be procedural in nature, and that is that it might not enable the parties to be on an equal footing during the proceedings, and financial reparations may not make up for that type of disclosure.
Autrefois, ça va poser des problèmes d'une nature.
You may have an issue where you have a witness does not want the state party to know his or her identity, and the counsel or the parties have agreed that things will be for the eyes of the judges only, but unfortunately, perhaps one of the state councils, unfortunately, I mean, you have to believe in the good faith of people, but someone might have sent an email sent a distribution list mentioning the name of this witness to all parties. And so that individual and the individual's family may have been put in danger. And so how would you then sanction that type of disclosure? The issue of sanctions or penalty really is something that I think is very important.
Thank you. On the point of the sanctions or the regulatory aspect, I think I just wanted to speak on behalf of the experts. They're trying to impose these obligations and they wanted to kind of have a mechanism to impose them. But as we have discussed, this is a brainstorming session. We don't know which framework we're in. We don't know which arbitration rules would govern. We don't know whether the appointing authority would have a role in such aspects. So it was kind of, in a sense, to kind of think about ways to impose the obligations that's put in there. I don't think it's a way that they are suggesting that this is the only way. So I think as part of the brainstorming process, if you could give your comments on that, that would be better appreciated. We have a few requests from the floor. I would like to give the floor first to Israel and then to the other public participants. Israel, you have the floor.
Thanks so much. So confidentiality is obviously a major issue for tech companies that enter a tech dispute settlement procedure for reasons such as protection of data and copyright. So Corinne Guta and Monica, I think, explained it very well. We did have a comment about draft provision 7, I think it was paragraph 2. We suggest to set the confidentiality of information as a default, which would mean requiring the party objecting to confidentiality to request that the arbitral tribunal to decide that it would not apply, rather than the current setup, which makes confidentiality, if we understood correctly, opt-in, at least in that provision. And a general comment about making reference to the WIPO rules, and this is part of the brainstorming that you just mentioned. We don't have any data on the rules, the WIPO rules, but the particular arrangement on confidentiality seems somewhat burdensome, with a sort of extra mechanism that might unduly slow down the process, which seems kind of at odds with what we've been saying, at least we've been noting about the need for speed in tech disputes. So before adopting the WIPO approach, it might be useful to obtain information about how the equivalent provisions in the WIPO rules are used and implemented and how they're perceived by litigants. Thank you.
We have two requests from the floor, from the public. First, I would like to give the floor to the Millian Chan.
Hi, the CPR Institute has the following comment relating to draft Provision 6, Section 1, which sets out exceptions to confidentiality of the proceedings and materials exchange in the arbitration proceeding. In our experience, a party in arbitration, particularly the respondent, will often seek insurance coverage for the losses and costs incurred in the arbitration. Many, if not most, insurance policies contain notification and cooperation requirements that must be satisfied to qualify for such reimbursement. Therefore, the party will be required to notify the insurer or the insurance agent, which could be a separate law firm or company, of the existence of the arbitration, as well as to provide updates and summaries of the evidence exchanged and often the evidence itself. Disclosure of information about the underlying arbitration may also be required if the party ends up having to appeal a denial of coverage in a new proceeding against the insurer. We do not believe that this scenario is covered in any of the 4 exceptions under Section 1. Therefore, we would propose a subsection E, which says something along the lines of, to the parties' insurers, reinsurance, or agents of the same, to the extent required by the insurance or reinsurance policies, and provided that the insurer, reinsurer, or agent agree to be bound by the same confidentiality provisions as the parties. We also believe that Section Paragraph 5 should not be required when one party shares information with its insurer, as that may negatively impact the insurer party's posture in any settlement negotiations. Thank you for your consideration.
Thank you. I just wanted to clarify whether this would only apply in the context of the insurance industries or whether it could be applied more broadly. But then I would like, would you have a response?
We intended to be applied broadly, but our experience relate to insurance companies. That's why we put forth what we have encountered.
Okay, we will take note of that, and then when we actually develop this further. Michael?
Thank you, Chair. Distinguished representative. Thank Chair and distinguished delegate from Switzerland mentioned the transparent issue in addition to the confidentiality issue. I address the issue of how to, quotation mark, attempt to obtain a balance between preserving confidentiality and ensuring sufficient disclosure to facilitate the proceedings, quotation mark. This quotation is from draft provisions for technology-related dispute resolution. I use ZKP, zero knowledge proof, as an example. ZKP, zero knowledge proof. To my understanding, one party, Alice, can prove to another party, Bob, that a given statement is true without leaking extra information. One party, Alice, is the prover. Another party, Bob, is the verifier. The prover offers verifier their no knowledge of extra information or sensitive information. Zero knowledge proof can be used to prove to the verifier that approval is older than the legal drinking age without revealing how old approval is. As we know, driving license, our ID has a sensitive information, not only age, but also the address. I give examples of zero knowledge proofs application. A mortgage applicant can prove that their income is in the admissible range without revealing their exactly salary. ZKP can be used to authenticate users without exchanging secret information such as password. This is about authentication. ZKP, zero knowledge proofs, can allow the owner of machine learning algorithm to convince others about the results of a model without revealing any information about machine learning model itself. This is about machine learning. We use like a code is not. A coder is a sanction. So sanction maybe it's not necessary. We use the zero knowledge proof. That's the example. I expect further clarification about ZKP, zero knowledge proof, from the distinguished expert in this UNCITRAL Colloquium. Thank you for attention.
Thank you. We have two requests for the floor. Well, first, I would like to give the floor to France.
Je pense.
Thanks. I think that the proposal on insurers, that perhaps maybe we should expand a bit, but I think the distinguished delegate from Switzerland will make an excellent suggestion to that end, which I will let him do. So I think this seems to be a very welcome suggestion. Nevertheless, we should perhaps be wondering if, in this case, the constraint between the financer and the finance parties, or the agreement between the insurance and the insurance, should perhaps have clauses to ensure the same level of confidentiality if there's a conflict that arises. If there's no such clause, and if these parties address their disputes before a state tribunal, we can't ensure the same level of confidentiality, and therefore we can have the insurance, I would think. Thank you.
Thank you. I was calling on Michael on the platform, but whether Michael in the room would like to. Then I have next on the list, Australia.
Thank you, Chair. Just further to the comments made by various distinguished delegates in relation to insurers, we also feel that perhaps we might need to consider litigation funders as well.
Yes, and I think that's going to be an interesting point in the sense that in Working Group G, we're also talking about transparency and disclosure of information about third-party funders and how the information from the parties should be conveyed to the third-party funders about the dispute has to be considered. So it's kind of both sides of the coin that we have to consider. Are there any other requests for the floor on draft provision 6 or 7? Switzerland, you have the floor.
In the discussion about the use of these rules, also those provisions that may be useful for the notes. And I think in this area, there is much that can be said in the notes which may not be suitable for the rules themselves, but the question of confidentiality can, in our perspective, be very well the subject of the variety of possibilities that arise and the variety of solutions that can be made. One area in which the confidentiality issue, not directly related to technology, is the information from competitors, which may be a relevant issue. And so our recommendation here is to consider certain aspects, especially I heard, I don't remember who it was, saying that the last two paragraphs in Article 7 there were doubts of whether they should be included in the rules. So the recommendation here is that further thought is given to the various solutions of protecting both inbound and outbound confidentiality. Thank you.
Thank you. With that, if there are no other comments, I would like to pass the floor back to the experts who prepared the draft. If Monica or Krenguta would like to have any last-minute responses, please. Monica, you have the floor.
Thank you, Jay, and thank you very much for the very useful comments. And I totally agree that the tweaks of some of the provisions might be helpful. As regards the exceptions, I have looked at the transparency provisions, and they are based on a bit different mechanism how they use. There is the presumption of publicity and then definition of the confidential information. So this is actually the exception. So, but I understand that this would be very helpful to explain it in the notes how it works together. As regards the insurance and funders, I was thinking about these two issues and thought that it could be captured under the exemption of under Article 6, letter A, to pursue a legal right. But yeah, it might be helpful to be more explicit. And I also very much liked Cedric's suggestions about actually changing the presumption of confidentiality of information in draft provision 7, meaning that actually everything is considered confidential unless the other party objects to that. That I think would streamline the proceedings. And the last issue, which is very interesting and probably very difficult to decide on, are the sanctions. I have seen it specifically in the Liechtenstein rules that impose directly in the rules, there is a sanction of, I think, 50,000 euros for each individual breach. The other option could be to simulate something what parties negotiate in a confidentiality agreement, to say that actually any breach of the confidentiality should be considered irreparable harm for the party. So this could be also a proposal for consideration, if this would be more helpful than to endanger the invalidity of the award, imposing a sanction that would be found prohibited under some mandatory laws. Thank you very much.
Thank you, Monica. Kranguta?
Thank you also for these excellent comments. There is one in particular that I would like to refer, because it is one that I feel that it is of specific importance, and that is the point made by the Swiss delegate on the knowledge as a risk. When we have arbitrators which are familiar with the specific technological issue, which is a cutting edge one, because they are familiar with the industry and potentially with the competitors of the parties in dispute, without having actually a conflict of interest to the parties. They may be into some other type of conflict of interest that is beyond the scope of the arbitration. And that is a very interesting notion, which worth being explored further in our work, because normally the conflict of interest is seen only towards the parties into dispute, but it is rarely seen as to other potential competitors in the market. So I noted that very fine type of approach, which I find very valuable, and thank you for that. And the second one, which is also brought by the same delegate, and also in connection with the same knowledge of the experts, is the risk of leak information. So for the information to be leaked. Now that is a matter of ethics, and that is a matter of behavior. That is not new, that has been at all times present in the word of the experts, where information about the case, which was of technical nature, was at all times at risk to be leaked to somebody outside the ecosystem, let's say, of the arbitration proceeding. For that reason, I believe that ethical standards that would be specific to the technology area might be one of the areas where we might wish to look a little bit further. So what is specific to ethics in terms of this behavior that we are already used to have in the arbitration, both counsel, parties, expert, witnesses? Thank you so much.
Thank you. Switzerland, on this point?
On the comment of Monica, the target of Article 7 is not only the protection of ingoing information, but the real problem is that a party, in order to properly present its claim or its defense, needs to reveal confidential information which it wants to prevent the other party to obtain. For instance, if there are two competitors in a dispute and one party has information that is related to its claim, but which would give an advantage to the other party, there is a need for this information to be protected from the other side, and perhaps even from the tribunal. This is the problem dealt with in Article 7. So you have an imbalance, and the risk of the violation of the right to be heard or the adversarial procedure. I think that maybe perhaps either in the clause itself or in the explanatory notes, something that should be highlighted, and that is the real problem with confidential information dealt with in Article 7. So it is the protection of the process in case of partial of revelation of confidential information. Thank you.
Thank you for that comment. Kanguta, you have your hand up. I think it's a legacy hand. I think one drafting point that we have faced in drafting other provisions is that information in the public or public information is quite difficult to define as well. Because when you're defining information is otherwise made in the public domain or which is in the public, what do we mean by that is actually something quite difficult to define. And I think if we are to develop this provision further, we would have to think about how to define what is public information and what is non-public information. So with that, I would like to close our discussions on draft provisions 6, 7, and 8. We have a few experts who are part of the experts that we have been consulting with but were not able to join previously. I would like to first give the floor to Manuel, who was active in coming up with the definition of technology-related disputes. If you can raise your hand, and then I would like to give you the floor. Manuel?
Yes, I was. Let me put my video on. Excellent. Thank you. Thank you very much, distinguished members of the working group and distinguished representatives of the states and other organizations that are present in New York and also virtually. I'll just make two brief comments because I believe that a lot of these discussions have been had already. And a presentation on the definition was made already, which resulted from a collective effort in which I participated along with Andres Hanna, Shai Shervit, and Miriam Feinberg. And I would like to add just because of how the discussion has evolved during the sessions, that there are two features that I would like to put for the consideration of the group that may be important, not only in terms of expanding a potential definition of what type of disputes should be considered for any provisions that become part of the agenda, but also the scope and also some of the other aspects, including evidence and including the use of experts in the proceedings and so on and so forth. As you may have heard during the presentation about the definition, the focus is not on the parties, on who are the parties, but what type of dispute, what type of transactions underlie the dispute. And that was a choice obviously made to expand the scope of the application of the rules, not only beyond technology companies who are perhaps the leaders, the ones that are the most visible users of dispute resolution for technology disputes, but there are many small and medium enterprises, state entities, as we just heard, that would have a stake, and I think that the working group would be a wonderful vehicle to legitimize the importance of specialized rules for technology related disputes. The new issue that I think is important, well, it's not a new issue, but it's an issue that has always been present in the discussion about technology disputes, is that some disputes are intertwined with the technology. And what I'm referring to is that sometimes the contract is not just in a normal document or in a verbal form as we are used to in a traditional format, but sometimes the transaction itself or the relationship itself is embedded in technology. We have examples from transactions or business relationships that are being embedded in blockchain technologies. We know that smart contracts could be used as part of a larger transaction. There are transactions that are entirely based on smart legal contracts, but there are transactions that are in some sort of a hybrid relationship. So that's something that needs also to be taken into account, that the underlying transaction may be a transaction that involves technology. It's intertwined with technology. And that would affect not only the consideration that this type of disputes require a specialized expertise from the arbitrators, for example, or the need for efficient and speedy resolution, but also considerations that are technologically important. And that will also affect, if we have an underlying transaction that has a disruptive or an emergent technology embedded in it, and obviously the dispute that arises will also have some new technology or some emerging or disruptive technology embedded in it, then that will also affect what type of evidence you obtain, how do you use it, how do you weight or consider the evidence, and many other issues that are also important to take into account. That's all I wanted to share. I just wanted to introduce this element that I think might be important to consider, because it's what we see being covered not only by the literature that refers to new and emerging technologies, but we see that the users that are and the commercial parties that are involved in this space are also very interested about. Thank you very much.
Thank you, Manuel. Having gone through the different draft versions, I think the experts might also right now, and the working group may wish to kind of revisit what was in the definition of technology disputes in draft provision 1 and how it could be applied either in the application or in the guidance to the parties. I know that we have two other experts that wanted to speak but was not able to take part in the morning session. I have asked them to raise their hand, but they have not raised their hand, so I'm not sure whether they want to take the floor or not. Gilad and Raheli, would you like to take the floor? Yes. Gilad, you have the floor.
Thank you very much, first of all, to everyone. And I'm sorry I didn't join to the earlier session. I would like to speak about section 4 and 9, which are dealing with the time frame. But before I'm going to address those sections, I want to give some thought about the logic behind it, because I think it's important to understand the reason for those clauses. First of all, for our experience, we have seen that there is a real need for a fast resolution and award in regard to high-tech and technology disputes. For our experience, we saw several times, whether we are representing international companies or local companies, that in those kind of disputes, the need for an immediate solution and award is very crucial, and therefore we thought about ways how to find solution to these needs. If we take from our experience the situations that or try to divide it to section, why it's so important to have such a mechanism which is relevant to this and give solution for high-tech dispute, we saw that at least we can identify several groups of cases which are all repeat themselves in this kind of situation. One of them, for example, usually a situation that there is a company which develop for another company or part of a big project of another company in technology project, and usually issues of dispute about scope, about what is included in the work, whether they need to do some adjustment, whether the criteria are met or not based on the parameters. Those things, when you are doing a project, and usually it's for a customer, for a third party, the need for immediate resolution is very important, because afterwards, if it will take a long time, it will not be any more relevant, because the project will already lost. The people who order the project will not wait, and all the project can go away. So usually, if you want to save the project, you want to give a real solution in real time, you really need a fast opportunity in order to find a solution. This is one of a group of cases that usually in this kind of situation are raising the need for immediate verdicts or immediate option of resolution that will give, within a limited period of time, the ability of the sides to bring it to the dispute, to find an immediate solution, and by that, hoping that they will not find themselves have the dispute when the project is not anymore relevant. Another category that I want to identify, and again, this is give the logic why we need this kind of regulation, is a group of cases which usually under transaction, usually investment of other companies, startup companies, more mature companies. When you are going to invest in those companies, always there is the questions that usually raised regarding ownership, rights, regarding issues of collaboration with third parties. All those issues, if you are under doing a transaction, again, the need for immediate finding a resolution in such kind of dispute is very important, because if you don't give an immediate solution, usually can lose the option of investment. I think everyone who deal with this kind of situation knows that a lot of time when it comes to an investment, something like that raised, and usually it's a trigger to raise those disputes from third parties or someone who was connected, and the investment could not be fulfilled in case of someone see that there is a problem or someone raise argument like that. And the need for immediate mechanism can give a good solution for these kind of cases. This again emphasizes why we need such rules or special rules for this kind of resolutions. And all those issues was the behind of what we have tried to gather in section 4 and 9 for the rules about giving a limited period of time of the wording, taking into account that within a short period of 20 days or 40 days, we can give a full resolution of the situation, taking into account that this will guarantee to the parties a solution that they can use it. And if there is still a call afterwards about monetary issues, things like that, that you can postpone for later, it's a different situation. But usually, by giving such a mechanism, can maybe give a solution on an immediate base and don't send the parties for a long time of arbitration, which will not be any more relevant. So if you look at, for example, in section 9, this talk about 3 options of a time frame for the wording. One is 20 days or 40 days if you have hearing itself, with an ability to extend it to 60 days. We also included in this section, and you can see it in section 9.4, an option of giving some sanction regarding the fees of the arbitrator in order to give him a real incentive to finalize the period of time of all this mechanism, showing or from other cases that we met, that usually some of the, if you give such incentive, the arbitrator really take into account the time frame and push the parties to really to stick to the times and try to really solve the matter in the time frame that we try to gather everyone into it. This kind of mechanism will be very helpful, and usually in this kind of technology dispute, which have uniques, and the uniques are usually the fact that this kind of dispute, as I explained, need an immediate solution in a lot of cases, or group of cases. They have a lot of issues that raised digital evidence, which not need a lot of person to be as a witness, and it can use a lot of documents usually, or a coding that you can detect without the need of presence of witnesses. And usually there is issues which relate to technology, so you need an immediate expert that will help in this matter, and we can, and then usually for a short period of time, can solve the situation and give in real time a solution for the parties. This is what we wanted to emphasize and explain why we saw so important this initiative, in order to progress it and find a real solution for these unique needs that we found out that the industry are looking for. And we saw it in many situations, many countries that we are working with in these kinds of circumstances, which are looking for such a mechanism. I think this is covering the matter that I want to emphasize regarding those sections. So thank you.
Thank you, Gilad. I think you by providing us the rationale for the draft provisions 4 and 9, which we discussed this morning, and also providing an illustrative cases of instances where immediate responses, particularly in a long-term relationship, is required, and then in order for the project to continue, which I think has been reiterated in the context of the adjudication as well. So I think the point that was made by the delegate of France in the context that we're talking in a long-term relationship with immediate dispute resolutions to consider and to continue the project is something that is kind of common in the two areas that we had touched upon on Wednesday and Thursday. Raheli, anything to add?
Yes. As Gilad say, I believe that we need to determine special rules for high-tech disputes. As Gilad mentioned, high-tech disputes require specific expertise and technical knowledge, and also special remedies and timelines. And I would like maybe to emphasize this through two cases. The first case study I would like maybe to talk about, and maybe this will emphasize what I would like to say. Something that is very common in high-tech disputes is that we have faced at the last year in practice at this point many times. We have, first of all, high-tech disputes happens when a company starts to raise funds or capital. In practice, at this point, many times another party, sometimes a former investor, raises claims with regard to debts or rights for options or stocks in the company. These situations can prevent the opportunity of the company from raising funds at all. We all know how important it is for high-tech companies to be able to raise funds. It is essential for high-tech companies, especially startups, that have a high burnout rate. Of course, such claims regarding the rights of a third party about its rights in the company can also create uncertainty regarding the status of the company's stocks and the dilution of the shares of the company. This obviously affects another potential investors that want to know the basic concerning the status of the company capital. A related issue in this context is of course, the scope of discovery obligation of the company with regards to the investment and the claims of the first-party claims. Another case study I would like to talk about is the loss of information. In a recent case, years of information of our client's company was lost because of IT problems, mails, data, and such. Restoring the information was impossible as the data was not backed up. The IT services provide of our client and contributed and negligence because our client refused to increase the storage quotas. The risk in this kind of cases is that it is hard to determine the damages. When large amounts of data lost, literally an entire history of the company, it is impossible to quantify the damages. In my opinion, this is unfortunate situations calls for consideration when we try to figure out what a good DR, dispute resolution mechanism, would like to be. So this is why I agree with Gilad that we need to set up specific rules. And first of all, we need to think about the evidence. As Gilad said, a unique feature of high-tech disputes is the fact that all or almost all evidence are digital. It is important to note that there is a big difference between legal systems regarding the scope and rules of discovery. Also, discovery usually starts after the parties submit their statements to the forum. I think that in high-tech disputes, we should determine a rule, and this is why we need this. We have to set these rules for preliminary discovery at very early point of the process. This is why also I think that the rules should give the arbitrator more ability to instruct freeze of evidence. So, as I said in the start of my things, I believe that we need to determine special rules for high-tech disputes. And I believe that these two cases that now I gave really emphasize this kind of thing.
Thank you, Riley. I think you gave an illustration of some of the disputes that we had in mind when we first started to define what technology-related disputes are. And of course, startups are issues, they face issues, and they need to have the disputes resolved in order for them to actually operate. And then, of course, as you mentioned, the high-tech disputes themselves have certain characteristics which require expertise to actually reach a resolution of the dispute. So with that, thank you so much. I think we have all the experts that have participated in the discussions contributing to the discussions. I just wanted to now open up the floor for any comments on the project as a whole. If you have any ideas, what could be more improved, what needs to be looked into. I also note that we do have the stock-taking project, whether this should be some part of the stock-taking project and what information is to be taken stock of. So if you have any inputs on that, I would like to open the floor for comments. And I see the request from Switzerland.
There are 2 points I wanted to make. The first one is the first of the 3 experts mentioned something which is quite related to the point I made on the second day, that is to say the arbitration clause. The context he described was very interesting and may require that we consider the provisions we have both in the model law, in the rules, and perhaps even in the New York Convention. What is the form of the arbitration clause in order to be binding? That may not be directly related to this project, but it is something that is a lesson out of the conference or the colloquium we had this week that definitely needs to be considered. The other point was the last speaker was in particularly interesting because she identified a certain number, certain types of contracts that are particularly affected. And in fact, the last 2 showed how important such urgent decisions are in certain circumstances. And what I took from them, one example was the development contracts or other contracts where a startup is negotiating or is having a project with a big company. Or other situations where you need a quick decision. The other point from the last speaker was very interesting. She mentioned share dilutions, the dilution of shareholding. That would be something out of shareholder agreements. So the issue or the concerns are much broader than just simply specific technology contracts. And that's the problem we saw when looking at the definition. So one thing useful for the continuation of this discussion would be if all those who have intervened or worked in this field give us more examples of situations in which these issues arise, and that may help us of addressing these needs in any rules we will be developing. So if the Secretariat could invite the experts to do what the last expert has just done, provide us with more concrete examples where the need of these rules arises. Thank you.
Thank you. Any other requests for the floor? Israel, in the room.
Thank you, Jay, and we also like to thank the experts, and we are very glad that we were able to hear from them and really to hear the examples, and we of course welcome the suggestion made by the distinguished delegate of Switzerland, and we'll definitely speak to the experts that we are in touch with to provide more examples. Picking up on I think what you mentioned, Jay, and also what distinguished delegate of France said, one idea which we could maybe discuss tomorrow, but we're just putting it now, is to think about the both the adjudication and the technology-related dispute as a holistic project. I'm not sure we need to really think of them as two different ones. We can think about a way to combine between them in some form, still focus on the technology, maybe add an element of adjudication and develop something that is part of this, and also something that may be independent. So this is something to consider. I just like to mention also that we did see a very good benefit of this dialogue between the experts and the working group delegates. And for us, at least, it was a shame that the experts couldn't come to this meeting. And even some of the delegates of the working group didn't come, probably maybe because this was, at least originally it was intended that some of the discussions would be only online. So that might have been the reason. We're happy that this didn't happen. But we think that what the two past days illustrated is that there is much room for dialogue between the working group and the experts, and for joint work on this. So again, maybe it's not the traditional way that UNCITRAL does things, but we are here innovating in the technology. So maybe one possible way is to at least have a couple of sessions or one session of the working group where experts and the delegates are in the room, hopefully, I mean, assumingly in person. And we think that could really benefit and highlight to the experts. We think that even some of the experts were able to be only part of the time because of the time difference. I can share with you that at least the two recent experts are online, and it's now, I think, 11:49 p.m. in Israel. So probably difficult for others as well. So just to say that we think this discussion was a very good one. We do recognize that there are a lot of difficulties, and this is a very preliminary draft, and much tweaking can be done for it. But generally, we think that there was much benefit to hear from both the experts and the delegates. And again, to stress that maybe we should consider an option which would not be working in parallel even, it would be working together. So it's not like these are two different things, because I think we heard the same reasoning for this, and hopefully, even if the title at the end would be technology-related disputes, maybe this could serve for other things as well. So this is just preliminary comment, and we'll probably make similar comments tomorrow, so maybe people would be less surprised. Thank you.
Thank you. As Itai mentioned, we will have a roundtable discussions of all the topics tomorrow, chaired by the chair of Working Group 2. But before we get there, if there are any other comments on this technology-related draft provisions, if you have any, please let us know. Karen, USA.
Thank you to the Secretariat and thank you to all of the experts over the last 3 sessions. It's been really very enlightening and also helpful to listen to the specifics and the types of challenges that have been laid out. I think the distinguished delegates from France and Switzerland have both, sort of honed in on an important point, which is that in this sense, the technology sector, how, whether broadly or narrowly or certain aspects of it, really as an illustration of the types of questions or challenges that come up when there's a need for some kind of interim quick decision to keep the relationship moving and the transactions and project or whatever the right contract is moving and not needing to go to full-blown dispute resolution as we think about it in arbitration. And it also seems to dovetail with the fact that the rules, as we all know, provide a good deal of discretion to arbitrators. So one of the things that we are thinking about, and I think the distinguished delegate of Israel has made an interesting suggestion that we can explore more tomorrow, is not so much that we are changing the rules or that we are trying to suggest that discretion doesn't exist, but what are some perhaps off the rack, as it were, what is the phrase, prêt-à-porter? I know I'm not pronouncing that probably right, but ways that we can structure some model tools for newcomers to arbitration, even though they may be sophisticated. So those are some thoughts that we've had in listening to the discussion. Thank you.
Thank you. Any other comments from the floor or on the platform? Nope, I think we have received all the comments. Yes, just before I give the floor back to Anna, Madam Secretary, just one last housekeeping. The comments on your list of participants should be received by now. If we will close the list and we'll circulate the final list of participants possibly tomorrow afternoon. So with that, I'd like to give the floor to you, Anna.
Thank you very much. Just listening to the comment by the distinguished delegate from the United States made me think that it could be a useful, when she mentioned a tool for arbitration for beginners, I'm just wondering whether this couldn't be an interesting addition to the efforts we're making in the secretariat to put together distance learning courses. We are putting together a distance learning module on arbitration and another one on mediation. So maybe that could be an interesting place where we could flag all these issues, maybe using technology and as an example, and complete, make the module maybe a bit more concrete through the addition of technology. So that's something we could definitely think about for us in the Secretariat to enrich our distance learning module, which is precisely meant to introduce arbitration for newcomers. Thank you very much.
Thank you. With that, I'd like to close the sessions. Thank you all for joining us online and in person. And we will have our roundtable discussions tomorrow, starting at 11 o'clock New York time. So I'll see you tomorrow. Thank you.